Okay, I'm going to get started. Good afternoon and welcome. I'm delighted that you're here. My name is Ann Pleckner, and I have been involved with Women Founders Network now for 12 years. I can't believe it. This is our 13th year in operation. And it's every year just gets more and more exciting. For those of you who are not as familiar with Women Founders Network, we are a nonprofit organization dedicated to helping women entrepreneurs. We do it in a variety of ways. We have educational programs like today's webinar. This is part of a whole series of webinars, so you should check that out on our website. We do record these webinars. Today's webinar will be recorded so that you can go back to the website in a couple of days and watch it again. Or if you've missed anything, you can go have another look. We also have mentoring programs for women entrepreneurs. And most importantly, we have an annual fast pitch competition. And this year's fast pitch competition, the application period is open through the end of the month. And this year we are awarding $55,000 of cash, no strings, no equity, nothing, cash awards to the winners of the fast pitch competition. So go to the website. If you have any questions, ping us. We're very responsive, and we hope you apply to this year's fast pitch. We also have a program that we call our Next Gen programs for high school girls and college women that teaches young women about investing, about venture capital, about entrepreneurial programs, because we think one of the ways that we hope to make a difference and we hope to move the needle on the amount of venture capital which gets awarded to female entrepreneurs is to get more women into venture capital and into areas like that, which right now are predominantly male. So this year, our high school girls, the applications just closed. We had over 100 girls apply to the program. We're really excited about that. And we also have a program, a due diligence program for college women. So stay tuned. Today's webinar is one of my favorites and one of the most popular. We're talking about cap tables. And so we will try to answer questions during the webinar if you, to the extent possible. So if you have questions, please put them in the Q&A section. And if they don't get answered during the webinar, there will be time at the end, and we will take additional questions at the end. So we have two amazing experts today. Kelly has been involved with Women Founders Network for a number of years now. Stubbs Alderton is just an amazing company and sponsor, and has been so supportive of Women Founders Network. So I am going to let these wonderful women introduce themselves. And Kelly, take it away.
Okay, thanks, Anne, and great to be here. Welcome, everyone. My name's Kelly Laffey. I'm a partner at Stubbs Alderton and Markleese. We are a full-service law firm, but our corporate practice particularly focuses on emerging growth companies, doing venture capital financings and other types of financings, as well as, going from early stage formation to your first big contract to, all the things that could come later down the road, including eventually to an exit. I also focus my practice on mergers and acquisitions and joint ventures and other strategic commercial transactions. I have my colleague here, Durdana Karim, who's going to be presenting with me, and I'll let her go ahead and introduce herself as well.
Hi, everyone. My name is Durdana Karim. I'm a corporate associate at Stubbs Alderton and Markleese, and similar to Kelly's area of practice, I do corporate transaction, which again is advising companies and entrepreneurs from the initial stages of formation to when the company wants to raise capital, and then to when the company wants to sell or acquire another business. Our clients range from variety of industries and technology, real estate, healthcare, retail, and professional services. And I think one thing that I really am passionate about, and which I wish I see more of, is companies and founders, female founders, and BIPOC businesses. That's kind of just something that I'm really passionate about.
Right. And today we're going to be talking about cap table basics. A cap table is something that a lot of people ask me about from very early to very late. We help with the cap table throughout the life cycle of a company's business. I just had a new client ask us for a cap table to send to investors, and it was the easiest thing to do because it was a sole founder. So you can just say you own 100% of the business. Of course, it's not always that simple. And so we're going to get into all of the nitty-gritty on it today. So this is just a little overview of the topics we're going to discuss today. We're going to talk about the components of a cap table. What is it exactly? When is it used? What's reflected? What isn't reflected that you might, it's sort of optional. We're also going to talk about how dilution works, especially with kind of companies that are looking for venture type funding. You think a lot about dilution because you know that you're going to potentially be raising capital not once, but maybe twice, 3 times, 4 times. And how are you going to get diluted throughout those financing transactions? We're also going to talk about issuing equity from an option plan, because that's another sort of hot topic with the cap table, is how do I give some equity to my key employees or my advisors, or, you know, maybe I even just have a very critical independent contractor who I can't afford to pay a lot of money, but they're very critical to my company. And so I'd like to compensate them in some other way. And then we're also going to talk about sort of how we think about the cap table and retention of control and ownership, and things to think about both at formation and when you're looking to raise capital. Just a quick note is that we're mostly going to be talking about shares or stock of a corporation, but the same concepts generally apply to LLCs. This may have been discussed at a different seminar that Women Founders Network put on, but if you are raising capital from kind of institutional and venture capital funds, they're going to want the company to be a corporation. But oftentimes, if you've got more of a family or small business, you might be an LLC. These concepts generally apply the same. I also have lots of clients who started off as LLCs and then they converted to corporation before they raised capital. So there's no like issue if you did form as an LLC.
A capitalization table, or a cap table, is a spreadsheet that shows the equity capitalization of a company. The cap table provides a breakdown of the company's equity ownership, including the number of authorized and outstanding shares of common stock, preferred stock, warrants, options, and other convertible equity, which is usually held by the founders, employees, investors, and other stakeholders. It serves as a comprehensive record of the company's ownership structure and helps to make informed decisions when raising capital, when issuing employee stock options, to determine the dilutive effect as a result of those stock issuances and grants. So it's just really important to maintain, you know, a well-kept cap table, especially when the company is going through different stages when it's raising capital. So it's really important to keep those up to date.
Yeah, and the other thing I'll just add to that quickly is that a cap table itself, like the spreadsheet that you create to be your cap table, whether you create it or you put it on a platform like Carta, it's not technically a legal document until you make it part of one. And it is very customary when you are entering into other legal documents, especially around financing or selling equity or transferring equity, that you will have to make a representation as to what the capitalization of the company is, and that's what the cap table will tell you. So that's sort of the, you know, 360 level view of why you need to keep the cap table up to date is because oftentimes when it comes to these major transactions, you will be asked, what is your cap table look like and what's the capitalization of the company? So it also shows you, or a cap table will calculate the percentage of ownership. I wanted to quickly just discuss authorized versus issued shares. This is actually very specific to a corporation. You can have authorized units or membership interests in an LLC, but it's set by contract as opposed to in a filing with the state. If for a corporation, you actually have to file in your charter how many authorized shares the company has. And so usually you start with sort of a big number to give yourself some flexibility. You issue maybe half of that to the founders, and then you have the rest to sort of, you can put it in an option pool, you can sell common stock to investors. You just have some room to play with before you have to amend your charter. If you have authorized but unissued shares, those do not get counted for purposes of the ownership of the company. Those are just authorized. They can be sold, they can be issued, but they're not actually issued yet, and so nobody owns them. Issued and outstanding versus fully diluted comes to more of a question of, are there options to purchase stock that have been issued or granted to either employees, service providers, strategic folks? Sometimes you'll see them issued to banks for purposes of like an equity component to a debt financing. So the issued and outstanding percentage is a percentage of who owns actual stock or shares that are outstanding in the company, whereas and it doesn't include things like convertible notes, safes, a warrant to purchase stock, an option to purchase stock. And then the fully diluted is just the opposite of that. It includes everything. So you're looking at a full picture of what your percentage interest is, assuming everything is exercised, everything is converted. And that gives you sort of a better picture of like what you're actually going to get if there's like an exit, for example. By the way, I see some questions in the chat. I am going to be monitoring that as we go, but if I don't answer a question in real time, I will try to answer it out at the end. So for now, we're going to move on, but I'm going to come back to these questions at the end. There's also a Q&A function, which might be easier to use, but we will look at both places.
Okay. So option pools. Stock options and stock awards are a form of equity-based compensation arrangement to compensate and retain, attract, incentivize employees for a growing company. Unlike when a company issues actual shares, stock options are granted by the board of directors of a company, usually issued through a stock option agreement and governed by a stock incentive plan, which gives optionees the right to buy a specific number of shares at a fixed price within a certain period of time, often with a vesting schedule. And then an option pool is a reserved number of shares set aside for those employees, officers, directors, other service providers. Typically, the percentage reserved can range from 5 to 25% of the fully diluted capitalization. It is important to kind of consider what the company expects in terms of its growth. Usually, you're not thinking about kind of how many employees you might be hiring. There are certain corporate formalities that are needed to be taken into consideration when you're, approving a stock incentive plan, approving the amount of the reserved. So it may be a situation where you'd want to make sure that you have enough reserve so you don't have to go back to the board to increase the board and stockholders to increase the amount reserved. And then sometimes when a company goes and does a VC financing round, certain lead investors may ask to top off or top up option pools, which is basically to increase the pool amount prior to the issuance of equity to them. This is a way to avoid diluting the investors later. So those are all kind of certain things to consider when you're looking at option pools.
I'll just pause really quickly to answer one of the questions in the chat. So one of the questions is about if this applies to both C Corps and S Corps. So yes, I mean, in as much as a cap table can be made for a C Corp, an S Corp, or an LLC as a picture of the ownership, absolutely. But one thing to keep in mind for S Corps, S Corps have certain restrictions, one of which is that you cannot have more than one class of stock. So anytime we're referring to sort of Series C and Series A, Series B, that could not apply in an S Corp. And so that's another reason why when you're raising capital from institutional or venture capital funds, they're going to want you to be a C Corp.
Okay, so how are cap tables used? Cap tables play a critical role in providing transparency on the ownership and facilitating effective equity tracking. They can be used in capital raising events, usually when you're negotiating with investors for new funding. The investors may want to look at the equity ownership to see, how much the founders own, how much equity options have been given to certain employees. Sometimes they may also want to determine what their percentage interest will look like after they've done the investment, and we'll go into something called a pro forma cap table. That's usually what's provided to project what the ownership will be after a transactional event. They're used for tax and regulation compliance purposes and often given to buyers when selling a company. Again, it's important to maintain a well-structured cap table as it provides informed decision-making about funding, growth, and the ownership distribution.
So how does dilution work? So this is also getting to one of the questions in the chat, which is why I waited to answer it. So dilution is basically how your percentage ownership is being decreased once the corporation issues new stock, whether that's to investors or to, option holders who are employees, service providers, etc. And generally speaking, everybody's going to get diluted pro rata or proportionately as the company issues more stock. When you create a stock option pool, you usually think about, because that pool is going to dilute all of the existing investors proportionately, but as long as you're staying within the pool, it's not going to further dilute anybody. And so that's why you want to think about, well, what's the appropriate size of that pool? And I think somebody asked about how many option pools can you have? I mean, you could have as many as you want, but there's really no reason to have more than one, because you can issue options from that pool to multiple people, or to as many people as you want. So sometimes you'll have two if you need if you have a voting security and a non-voting security, and you want to issue options that are voting to some people and non-voting to other people. But typically options and incentive grants are relatively small, so the voting power of those folks is not incredibly significant. So we very rarely see more than one plan at a time. You can enter into an agreement where somebody will basically not be diluted by additional equity issuances. That's called like a non-dilutive issuance, or a non-dilutable issuance. It's not something I recommend. It's not standard, and generally speaking, unless there's a very, very, very compelling reason to do it, future investors will not like it and will usually request that you renegotiate it so that it is no longer non-dilutable. The other thing to keep in mind is that preferred stock has what's called an anti-dilution feature, which is not that they don't get diluted, but when you think about selling stock at a valuation that's less than the valuation you may have raised capital at before, that's what's called a down round. And so those shares have anti-dilution protection where they get, it's called a, what's it called? Weighted average, broad-based weighted average calculation, so that they get the benefit of some protection for the company having raised in a down round. That's sort of outside the scope of this conversation, but I did want to mention it because that is actually a pretty standard feature of a preferred stock. And I wouldn't push back against that in a typical equity financing round. Good dilution is what we want, which is that your percentage is going to decrease, but as long as the valuation is going up, you're just getting a smaller piece of a bigger pie. So the value of what you own is theoretically staying the same, or at least on paper, it's staying the same. That we do have an example of that as well. So this is just an example of pre and post funding founder percentages. It's a little bit, we try to simplify it as much as possible, but it can get complicated. But I just wanted to show kind of what would happen in a typical financing round where you're getting diluted because additional shares are being issued. So here you have, at the top, you have your founders and you have your initial option pool. We didn't include an increase to the option pool at the bottom when you're issuing your Series C, because that would also add complexity to it. But usually in a financing round, you're also going to be topping up your option pool so that there's more shares in it, and you can incentivize additional service providers. But just showing, here the founders hold 85% collectively, and after selling, after raising $200,000 at a $1 million pre-money valuation, they're getting diluted down to 70%. We're also going to talk a little bit more about kind of pro forma modeling in connection with financing rounds. It's a very important exercise to do. We help our clients with it a lot. Carta has a tool for it now, which might be helpful as well if you are on Carta. But it's very helpful to see, like, okay, if I'm raising this much money at this valuation, what does that actually mean for my percentage ownership after I do that? So that's what this is showing. I believe this slide deck will be shared after the presentation as well. It's also being recorded, so you can see it.
Okay, pro forma cap table. A pro forma cap table it allows founders and investors to see a projected ownership structure after kind of a transactional event, such as an investment round. It evaluates the current ownership structure and predicts the ownership amounts after that event. This data is crucial for potential investors to comprehend the company's equity structure, how equity is allocated, how much each shareholder holds, including how much the founders will be holding before and after. And it helps with negotiating the equity value and determining the value of the company. Again, some of the kind of benefits of it is that it's helping to evaluate the effect of the equity raises on ownership structure of the business, assess the ownership structure of a business after a merger or acquisition event, examine the possible dilution effect for outstanding shareholders. And then we'll give an example of kind of what a pro forma cap table looks like.
Yeah, so this is a company where they've raised some money in a safe first, which is very common for early stage companies. A safe is a contract that basically says you're not getting shares yet, but it's basically a promise that you will when the company raises additional funds in an equity financing, and it converts on a specific calculation, which is either based on a discount to the next round price or it's based on a valuation cap. So, this will convert either at 80% of the next round price or price determined by using a $2 million valuation cap is something that you might see. Whichever one is less, whichever one gets the investor more shares is typically what you're going to see in a SAFE. Here we have a 15% discount. They raised 200,000 in the SAFE. Now they're raising $1 million at a $9 million pre-money valuation. And so we've calculated the price per share based on what the existing capitalization is as 83 cents. And then 85% of that is 71 cents. So one thing to keep in mind also is that, what's going into the calculation of the price, the new money is never going to get diluted by the safes. They're going to want to, they want that to convert into the pre-money. So those SAFE shares that are being issued will be included in the fully diluted capitalization for purposes of calculating that price. This is, again, it's a little bit outside the scope of this conversation, but it's important to look at the SAFE language to see if it's a post-money SAFE or pre-money SAFE, to see if it also gets diluted by other SAFEs and convertible notes and things like that. But yeah, and then here again, we did not include an increase to the option pool, but oftentimes you will be required to top up your option pool so that the investors are not getting further diluted by additional option and incentive grants. That option pool top up will also be included in the fully diluted pre-money capitalization for purposes of calculating the price. So that way, the Series A investors will always get their 10% of the company post-closing. Somebody asked about tools to assess valuation. I get this question probably every single time I give any presentation, whether it's this or term sheets or talking about safes. Unfortunately, no, it's more of an art than a science, especially at this stage, at the early stage. It's really hard when you don't have necessarily revenue or other financial metrics to sort of put yourself against and figure out the right multiple. So it's really a matter of, what are your financial goals? What are your projections? A really good exercise is to do a financial model so that, assuming, conservative assumptions, like what's our expected revenue once we actually do launch, that can help you to put together a valuation.
Also, Kelly, we will be having a webinar coming up on June 26th, which will go into a little bit of valuation of a startup.
Oh, great. Yes, you should definitely go to that. Yeah, how did I get the 9 million? We just plugged in 9 million because this is not a real company. So we didn't do anything to get there. That is a good question though about, do I need to perform a valuation? So there's different uses for valuation. Obviously, valuation is really important when you're raising money. How much am I giving away for as much money as I'm raising? But the other is when you're granting stock options, those have to have an exercise price equal to fair market value. The value used for that is likely not going to be anywhere close to what you're using for the financing, because you want to incentivize your employees, right? So you want to use the lowest defensible value, whereas the financing valuation is going to be as high as possible because you don't want to give away as much of your company. So we use what's called a 409A valuation. 409A is a particular provision in the tax code which says stock options have to be granted at fair market value. And yes, industry practice or best practices is to get a 409A valuation every year or after any sort of material transaction, whether that's a material revenue generating transaction or a financing transaction or something similar, whichever comes first. Okay. So thinking about cap tables in terms of retaining ownership. So at formation, there are some things you want to think about when you're thinking about retention and making sure that the people who are holding large parts of equity are either very involved in the business or, you know, don't have any reason to sort of not be available to you. When you have multiple founders, for example, you know, maybe you're splitting it all equally, a third, a third, a third for 3 founders. But if one person, if founder C decides, you know, on week 5 that they're not interested in this anymore and they want to go work for Google or something instead, you know, should they walk away with a third of the equity? Probably not. So we put in place vesting for service providers, even founders. If you're a solo founder, I think you don't necessarily need to do this until you've got investors, and investors will sometimes require like some revesting of founder equity. But when you have multiple founders, we do highly recommend putting in some sort of vesting schedule. Maybe it's, you know, 2 years, maybe it's 3, maybe it's 4. The typical sort of employee vesting schedule is a 4-year period with a 1-year cliff. So like they're not going to vest into anything until they've been with the business for at least 1 year. I do, you know, caution people about granting equity too liberally. Although it really depends on your philosophy when it comes to equity compensation. I have clients who grant equity from C-suite down to the receptionist. Everybody's got a piece in the business and they all feel a sense of ownership. There are different amounts, of course, but you know, they all have some ownership in the business. And then I have other clients who are, you know, a little bit more frugal with the equity and want to just use it for very critical key people. I think this caution is more about vendors, contractors, maybe people who aren't even employees, where you're just trying to save money. That's fine to do, and sometimes you have to do it, but you have to really think about what that looks like going forward and when you're going to need to get those people to sign something, or you know, if they exercise a stock option, for example, you want them to sign on to like a stockholders agreement, which says that they'll basically agree to sell the company when you agree to, because you don't want to have a very small holder kind of making issues later on down the line when there could be substantial value at stake. At funding, like I said, or like we referenced before, modeling the pro forma is very useful. You have to look at not just ownership and value, but also control. You know, typically we like to have founders have voting control through the Series A if possible. It's not always possible, but there are ways that you can negotiate certain protective provisions where the founders will need to agree to certain things also before the company can take drastic action, things like that, if they're losing kind of the majority voting control. And then, you know, I wouldn't think of dilution as like a bad word. Dilution is completely normal, and it's part of the life cycle of a business where you're going to raise capital through selling equity. So you just really need to pay attention to the valuation and what impact that's having on the existing stockholders and the founders in particular. Obviously, I feel like this is a founder audience, so I'm sort of gearing it towards that. But you know, that's dilution.
So in preparing and maintaining cap tables for your company, it's important to keep the cap table current, include comments when helpful, especially for convertible equity, when there's vesting schedule for stock options and awards. It's also important not to promise percentages for new hires. A lot of the times I've noticed that, and entrepreneurs and founders will come to us saying, we want to issue 1% to one of the new hires to an employee, but that 1% necessarily might not be an actual 1% when the company does an equity financing. And so it's better to provide a fixed share amount or unit count. Or at least to specify that this percentage is for this specific date, making it clear that it will go and have ordinary dilution. To observe, of course, certain formalities, corporate formalities, including getting board consent, stockholder consents for approving stock incentive plans, and then board consents for approving equity issuances. Using vesting for equity issuances to service providers, including co-founders, and then also to consider using an online cap table management platform. Card is one of the really great examples of that.
Yeah, I feel like Carta is one of the most used platforms, but it's certainly not the only one. I think AngelList has one, and Cake Equity is another one, and JP Morgan Chase might have even come out with their own. So definitely, shop around. I think it is definitely like your attorney or even your accountant probably could help you with maintaining your cap table if you're not comfortable using Excel. But once you're beyond 10 to 20 stockholders, it really makes sense to get on one of these online platforms, because it's not only helpful to you to just keep it up to date and know that it's being entered appropriately, but that also ensures that the people you're granting equity to can see what they own, and they have their own little portfolio view where they can see, how many shares they own, what percentage of the company it is now. They don't have to have access to the full cap table. It's just like what they have. So it's a really nice tool. All right, so we got through that pretty quickly. But does anybody have any additional questions?
Kelly, I hear a lot that, oh gosh, have as few investors as possible, and new investors hate big complicated cap tables and hate having a lot of people that already own stock. Can you address the pros and cons of having a lot of people under cap table?
So obviously the cons are, how many people do you have to sort of answer to and update on a regular basis? And potentially if they all have sort of voting rights and maybe a large voting block amongst a lot of people, that's a lot of people you have to go seek the approvals from when that kind of thing comes up. It's just a reality. Most of the women founders I know who have been successful at raising money have done so by taking small checks from a large number of people. So I hear that, and from a sense of ease and practical perspective, wouldn't it be nice if we could just raise $5 million from one person? Of course. But that's just not the reality. So I wouldn't shy away from taking small checks, because sometimes those are the ones that you can get, and that's what's going to get you to the bigger check. There's also, I guess I'll just mention quickly that you can raise capital from non-accredited investors through like a Reg CF raise through these kind of crowdfunding platforms like WeFunder, MicroVentures. There's a bunch of them out there, and it's a pretty light lift in terms of what you need from like legal to kind of help you set that up and just start raising small amounts that way. What's nice about those is that they'll usually form an SPV that those investors are investing into. So it's usually just one line on your cap table that's like the we funder SPV, comma LLC. So then, they have to appoint one person to be the manager that can sign on behalf of that entity. So they at least are kind of coming up with solutions in that way. And I've also even seen some angel groups like put together SPVs so that it's just one entity on your cap table that's the investor, even though it might be multiple angels that went into that.
Okay, we have some questions in the chat and some questions in Q&A.
Sure. Okay, so I'm going to start with the chat. Are publicly traded companies required to share their cap tables publicly? No, but they do have. So I'm not the best resource for public company knowledge. My partner does that, and I try to stay away from it. But I know enough to be a little bit dangerous. And I'll just say that once somebody owns a certain amount, I believe it's 5%. Like once you own a large portion of a public company, that has to be disclosed, because that is sort of seen as trying to get some like controlling block of shares. How will that apply for grants, which is free money, especially for a new small business without profits yet? I'm guessing that this is a question about the 409A valuation and the stock options. So stock options have to be granted at an exercise price equal to fair market value. So the exercise price is what the recipient will pay to actually purchase the stock. Oftentimes, very often actually, the stock option is never actually exercised, so they never have to pay for anything. But if there's an exit, a liquidity event, they'll just get the consideration in excess of the exercise price per share that they had. So if you granted somebody an option at 10 cents a share, and then the company was sold for $1 per share, they would get 90 cents per share that they had, or per option grant that they had. So that's usually how that's dealt with. You can also grant restricted stock as opposed to a stock option so that they actually get the equity on day one. The issue with that is that they'll have taxable income equal to the fair market value. So again, using that 10 cents example, if you grant them one share that has a fair market value of 10 cents, they'll have 10 cents in income that they will then have to report to the IRS if it's vesting. They also have to file an 83B election. And so granting equity to service providers is a technical and complicated thing. So it's something I definitely recommend getting counsel to assist you with, at least in the beginning, so that you have all the right processes in place to do it. It's it's a big tax minefield, and we don't want to create tax issues that we don't have to. Let's see. If I'm an LLC electing to be treated as an S Corp, how should I go about giving equity to my key employee? I'm planning on giving them equity this June. So that is a very specific question. I think you'll need to talk to a tax advisor about that, because it depends because of the S Corp status. So I would recommend reaching out to counsel to discuss the best way to do that. If valuation decreases, does it have impact on fair market value for options that were previously issued? No. So your options have to be granted with the fair market value as of the date of grant. But if your valuation if your 409A decreases after you've granted stock options, you can reprice those options, but it'll be treated as granting new options as of the date of the new 409A. So it doesn't automatically change your old options, but you can grant new ones. You can still give vesting credit for whatever is vested under the old options, but they'll be treated as granting new options, essentially. Just look at the Q&A. Can you talk a bit about A friends and family funding round. Well, it's sort of a broad question, but a friends and family funding round is really just that. It's where you go to your friends and family who might have some money and ask if they will invest in your company. Usually friends and family rounds are done on like a safe or convertible note, so they're not actually buying shares yet. That's also a little bit out of the scope of this presentation. I did another presentation on term sheets and fundraising rounds for our pre-accelerator that's available on YouTube. I think someone else did a term sheets presentation for Women Founders Network. So there are some resources out there that talk a little bit more about terms for safes and convertible notes. But the one thing I guess I'll just say, because it was already mentioned, is that if you're doing a traditional friends and family round where it's like a private placement, you're going directly to your friends and your family, they do need to be accredited investors. There's a number of ways they can do. It's usually an income requirement, but they do need to be accredited. If you want to raise money from friends and family who are not accredited, you have to go the crowdfunding route and do it through a platform like WeFunder or MicroVentures or something like that. Let's see, let me read this question. Yeah, so the question is about what happens with options versus stock or RSUs if an employee leaves the company. So yeah, typically a stock option has a 90-day exercise window after an employee leaves, and that's for the vested options only. And if they don't exercise, then yes, they fall away. Sometimes a company can extend that exercise period to the 10-year anniversary of the date of grant or something in between if they, want to kind of be deferential to the employee and give them some additional time to exercise. But yeah, that is typically true. For stock, if you've been granted stock, unless there's like a forfeiture provision, which sometimes there is, or a repurchase right, then yeah, they would just keep it. For an RSU, that the same, because I think on an RSU, once it vests, the stock is automatically issued. So you would continue to hold the stock unless there's a repurchase right. Sometimes the company has a repurchase right to buy it back at fair market value, or if the termination was for cause, it could be some kind of nominal amount or discounted amount. But yeah, that's typically how that's handled.
So Kelly, I have a question, because we hear a lot of horror stories over the years, and a lot of attorneys who say, oh my gosh, if only the founder had done blank, then we wouldn't have this big fat mess. So what are the most common pitfalls that early founders fall into that creates a mess you need to clean up later? And how do we avoid that?
I mean, the common ones I see are kind of granting too much equity off the bat, not thinking through kind of retention of control by trying to like incentivize or trying to grant equity in lieu of cash for services, and how that would impact the company later on when you need to go to, maybe you hire like a development company to do your initial website or product or like MVP or something, but like that's not who you're gonna be working with for the majority of your company, and it's those relationships can get very challenging. The other thing is, in terms of the cap table, is just not understanding kind of how things are going to progress in terms of share numbers. Even like if you only issue 100 shares at the beginning, you're going to be getting into like tiny fractional share amounts. So that's why, our typical capitalization is like 10 million shares. And so if we have somebody that comes in with only 100 or 1,000 shares, we'll do a stock split so that, you know, the share number count goes up, because you, generally speaking, just don't really want to get into issuing fractional shares. Durdana, can you think of any other horror stories you've seen lately?
No, I mean, when you're issuing percentages to employees, officers and directors, rather than, providing the fixed amount. I think that's also just something to consider, because oftentimes you come in and you're saying, oh, I want to issue 1% or 2% to this officer, director, employee, but that's not really what they'll own later on. And so that's kind of important to consider.
Yeah, the psychological impact of promising percentages
Yeah.
is really huge. The other thing too is because safes and convertible notes are so commonly used at the early stages, and we honestly recommend them. I'm certainly not saying don't raise capital on those, but it is important to model out those converting as well, because if you continue to raise a lot of money on safes and convertible notes, like, you have to understand that is diluting the founders more and more and more depending on the term. So that's why it's just really important to do a model, kind of make some assumptions about your equity round, and see what that looks like. Is fair market value of option stock? Yeah, it's a current valuation. And the 409A, a 409A is an independent valuation. So it is, well, the board can determine a valuation, but the best practice is to get an independent valuation firm to do the valuation once you've done any sort of financing or generated any kind of revenue. So I would say board determined at the very early stages is fine, like very, very early stages is fine. But then once you've raised any kind of money, you're going to want to get an independent valuation, but it will be as of the current date.
Hey,
Questions?
any more questions? Last chance. Okay, well, thank you, ladies, so much. Again, wonderful to have you here, and delighted with all the expertise. For everyone who's attending the webinars, you can go onto our website and you can see the webinars that we have already given, both this year, last year, and the year before. Some of the topics, you'll probably see Kelly's term sheet webinar from a little while ago, so you can dive in and re-watch some of our past webinars. And we also have some additional webinars coming up this year. June 26th, we will be talking about valuations, which is sort of unique to startups, who some of whom are pre-revenue, so we'll address some of those issues. So ladies, thank you so much. It's always wonderful to see you, and we certainly appreciate not only you doing this webinar today for Women Founders Network, but your company's support over the years of Women Founders Network. So everyone, I hope that you continue to follow us. Our fast pitch event, the application period closes at the end of this month. And this year's big fast pitch event will be again at UCLA. And this year it'll be on October 29th. So thank you, everyone, and everybody have a great week.
Thank you.